This is Carl Oppedahl. I'm delighted to be here to introduce this webinar in which people from the U.S. Patent and Trademark Office will do their best to try to help explain the America Invents Act and answer questions about the America Invents Act. This is a very exciting time for all of us as practitioners, of course, and we are so fortunate to have the help of these people from the U.S. Patent and Trademark Office. The people you're about to hear from are Hiram Bernstein, who is a senior legal advisor in the Office of Patent Legal Administration. Mr. Bernstein has been closely involved in the rulemaking activities that you're going to hear about in this presentation, the patent-related rulemaking activities, and he's going to share with us observations and comments. Many of the observations will be at a very high level, describing the sort of policy and functional results, but you will also hear some comments from him that affect day-to-day practice. The other speaker we will hear from is Sally Lane, an administrative patent judge in the Patent Trial and Appeal Board, which is the successor to the old Board of Patent Appeals and Interferences. Judge Lane is very experienced, has been on the board for a long time, and has been closely involved as well in the rulemaking activities relating to the America Invents Act. We are very fortunate to have her here with us today. I will now hand the microphone to Mr. Bernstein, and I will say welcome to our audience.
Hey, thank you, Carl. Before I start in on the actual slides, I want to put in a pitch for one of the products that we put out there. And on our website, we have FAQs, frequently asked questions. Now, personally, I'm not really a fan of FAQs generally because sometimes we tend to rush them out and we just say, well, you know, is there a fee and how much is that fee? But we're getting better at that, and we're coming out with more nuanced issues now. And if you hit the button on the frequently asked questions right now, you will get them for all the topics and patents. They run 22 pages, but we're not done. We're going to come out within a couple weeks for even more questions, particularly maybe some of the inputs that we get from here, some of the questions we get during this seminar. We will create frequently asked questions, and you'll actually have those in writing then, the answers that we give you. So please keep that in mind as you're going through all the materials. Try and get the FAQs also. Okay. What I'll be doing is the three topics: Inventor's Oath or Declaration, Preissuance Submissions, and Supplemental Examination. And I will start with the Inventor's Oath or Declaration. U.S. practice required in the past the inventor to be the applicant. The AIA now permits additional types of applicants. You can have assignees who are applicants, where an inventor has actually executed an assignment. You can have obligated assignees, where the inventors who have obligated themselves to execute an assignment. We see those by way of an employment contract. And then we also can have PIPs as applicants. Those are proprietary interest persons, persons who otherwise show a sufficient proprietary interest in the matter. Now, how does a PIP establish themselves? Well, that's not a new concept. They usually do that by legal memorandum, and that type of legal memorandum, what to do, is explained in MPP 40903F. And, of course, inventors can still be applicants. So we can now have inventors being applicants and executing decks, assignees being applicants and executing decks in the form of substitute statements, which I'll talk about in a little while. We just need to keep straight the party that we're talking about and what is that party doing, filing an application or executing a deck. Okay. In meeting the requirement that an inventor continue to execute an oath or deck, even where the inventor is not the applicant, the requirement can be met by the inventor, a couple of choices, the inventor executing the standard oath or deck, of course with updated AIA statutory language, or use of an assignment of the invention by the inventor where the assignment also contains the required information and statements of a deck. And the third alternative is a substitute statement by other than the inventor under certain circumstances with respect to the inventor, which I'll talk about in a moment. Okay, you will need, of course, to change your forms for oath or deck. New forms are on the office's website. You go to the form site, and it's forms for applications filed on or after September 16th, 2012. They have an AIA designation rather than the standard SB designation. The AIA has added additional language that must be present in the decks now, and one of the languages that they've added is the application was made or was authorized to be made by the person executing the deck. An additional change of language is found in 115I of the statute. There is a new penalty clause referring to imprisonment of not more than 5 years. Personally, I'm not sure whether that was meant as bad news, and that you can get 5 years for any violation, or good news. Don't worry, it won't be more than 5 years that you'll be spending time there, and maybe you'll get time for, time off for good behavior. Okay. The original inventor requirement that the inventor is an original inventor is still retained. Now, some requirements have been eliminated. The inventor executing the deck need not identify any other inventor, provided that the entire inventive entity is set forth in an application data sheet under Rule 76. An inventor's citizenship need not be set forth, and an inventor need not state that the inventor believes himself or herself to be the first inventor, as we are moving to a first-to-file regime rather than the old first-to-invent regime. Foreign priority claims under 55 have been changed. They must now be set forth only in the application data sheet to be effective. Presence in the deck, as in the past, will not be an effective foreign priority claim. Similarly, domestic benefit claims under Rule 78 must also be set forth in an ADS. Presence in the first lines of the specification will not be effective. What we're trying to do here is give you one place to put them so that we have one place to find them. And I think it will be helpful on both sides of the equation here that you understand where you have to put it, and we understand where we need to go to look for it. Okay, the deck need no longer acknowledge the duty to disclose material information under Rule 56. And the deck need no longer state that the person executing the deck has reviewed and understands the contents of the application. Now, let me make this clear. These requirements have not gone away. They just need not appear in the deck. The requirements are still present in the rule. So, if a practitioner feels more comfortable in having an inventor sign off on these type of statements, these statements may continue to be present in the deck. Now, one can, as a general concept, one can always add additional information to the deck, so long as the minimum required information is met. Just remove the indications that you are now using an office form. You have to take out the OMB information and the PTA SB designations. It's discussed a little bit more in Rule 1.4D3. Okay, the circumstances where a non-inventor applicant, an assignee, an obligated assignee, or a PIP can execute a substitute statement in lieu of the inventor executing an oath or deck are where the inventor is deceased, the inventor is legally incapacitated. We no longer call inventors insane anymore. They're legally incapacitated. Or where the inventor cannot be found or reached after diligent effort, or in fact the inventor just plain out refuses to execute a declaration. One thing to keep in mind, a legal representative, while making an application on behalf of the inventor, can execute a substitute statement on behalf of a dead or legally incapacitated inventor. I think assignees will appreciate this. If the assignee becomes the applicant, they no longer need to go to the legal representative of the deceased inventor, who is often a grieving widow, and have her try and participate in this process. So that's, I think, a good advantage. Okay, so what's the contents of a substitute statement? Well, obviously it requires the information and statements that would be required in the regular 63 oath or deck. You need to identify the inventor for which the substitute statement is being submitted. Obviously, it's probably not going to be all your inventors, but perhaps so. Identify the person executing the substitute statement and the relationship to the non-signing inventor. Well, I'm the assignee of the inventor, perhaps. And also identify the permitted basis for submitting the substitute statement. Now, the inventor flat out refuses to execute it. Here's a note for you. Just keep in mind, if you take a look at this, the absence of proof of facts that was present in a 47 practice, where if you had a non-cooperating inventor, you'd have to file a petition to the Office of Petitions under Rule 47, and they would want to take a very close look at what it is you've done. Frankly, I think it was a toss-up between having to go through a 47 petition or a root canal for practitioners who were faced with that type of situation. Although I've heard Carl in the past, and he made a good point, even though this process is a lot more liberal, just keep in mind that you need to keep records about this stuff, because 10 years down the road, if you are in litigation, you may have to produce evidence of having done a good faith attempt to contact the inventor. Okay. Let's talk assignments here. An assignment can serve as an oath or deck if it, of course, includes the information and statements that you would normally put in the oath or deck. A copy of the assignment has to be recorded in the office's assignment database to use this type of an assignment as an oath or deck in an application. Now, the best practice for recording and meeting the requirement that a copy of that be put in the application. I'm taking a dramatic pause here because I really want you to do this. And that is use ePass to electronically record the assignment. If you do that, the office promises that it will then forward a copy of that assignment to the related application. If the recordation cover sheet contains a conspicuous indication of a dual purpose. Now, we're not going to let you freelance with that conspicuous indication. We give you a checkbox. So use the checkbox, do an ePass, and we will put a copy of that in the application for you. Okay, submission of inventor's oath or deck or substitute statement can be postponed until the application is in condition for allowance, provided a signed ADS, application data sheet, has been submitted identifying the entire inventive entity. Obviously, if you're going to postpone the deck that has the inventorship on it, we need to know the inventorship up front so that we can do examination on it. Now, you can do this postponement, but you cannot do it for reissue applications. For reissue applications, you need to have the deck up front as usual. Now, keep this in mind. Where an application is filed with all fees and an IDS, because you intend to postpone the declaration, a notice to file missing parts of application will not be mailed. If we get the ADS and the fees, we're happy for now. A notice of allowability will be mailed requiring the deck. So you won't have anything to docket that you're going to need this until you get the notice of allowability. And then what's going to happen is you're going to get a 3-month non-extendable period for reply. Keep in mind, and this is just speculation, it's not written in stone, the office is considering in separate actions imposing a $1,000 fee for a 48 request when there is a postponed submission, And there may be some loss of PTA time if we have to go out with a notice of allowability and then wait for your deck to come in. So just because you can do something, that's the old saw, that doesn't mean you have to do it. Plus, in fact, the longer you wait, the harder it is, perhaps, to get the signature that you want. Okay, another change here in identifying the inventor. The references to family and given name have been dropped. From my point of view, a family and given name, I understand what that is, but if someone is living in a village and they take the name of the village or whatever, it's been some problems for us. So we introduced a new concept. A new concept is just use the inventor's legal name, and we will allow you to determine what it means to have a legal name. Okay, the last slide here is just some summaries of some of the changes here. I won't take the time to go through those.
Okay. Thank you, Hiram. I'd like to actually take a couple of the questions that have come in, and I'll read off a couple of the questions, and we'll see what we have here. One of the questions is, will the USPTO provide forms that serve as the combined assignment and power of attorney? Answer, no. The USPTO is not in a position to opine as to what assignment language would work in one or another of our great 50 states, and so you're going to be on your own. If you are in a position to give an opinion as to a particular state what counts as a good assignment, you could design your own assignment form. You could then add in the power of attorney, I'm sorry, did I say power of attorney? Assignment and declaration. You would then add in declaration language, and you could construct something in your own word processor to serve as a combined assignment and declaration. But you're not going to be able to count on the Patent Office to provide that form for you. Did I get that right?
Yes, indeed. It's a lot like when we have conflicting assignees. They both come in saying, this is what shows us to be an assignee. What do? That's in Section 324 of the MPP. We have two different parties saying for some reasons that they are assignees. What do you think we would do in terms of settling that dispute? Well, our answer is simple. Who filed the application and paid us the money? And if we get that dispute, we're going to go with the person who filed that application. And if the other person wants an application, the other assignee, they can file their own. But this is something for state law, and we're not going to involve ourselves in these type of issues.
Another question that has come in is this all-important application data sheet, which would be required in almost every patent application. There would only be relatively rare fact patterns where a patent application would not require an application data sheet under the new rules. Can that be e-signed, or does it have to be ink-signed? And the answer there is it needs to be signed in compliance with 37 CFR 1.4, and that does permit electronic signatures, what I call virgule signatures, signatures with slashes. That is permitted, same as before. In other words, that part has not changed with the new rules or with the America Invents Act. Oscar, another question has come in. This checkbox on the cover sheet seems complicated, and can't we simply do what we've done before? If we have a dual-purpose document, an assignment and declaration all in one document, can't we simply e-file it twice, once in ePass, once in EFS Web, and be done with it? Wouldn't that be sufficient?
Okay, remember the dramatic pause that I took? That was to encourage you to do only one thing, and that was to ePass submit it. The EFS Web, if they get it, they will not give us a copy in assignment branch. They're just going to put it in the application. Particularly keep in mind that when to record an assignment against an application, you need the application number. So if you're filing the assignment with the application, there is no application number that the EFS Web can deal with. When we get it in paper, what we do is we send off the paper to assignment branch. But I really don't want to discuss these other options because don't do them. So my answer is no. Use ePass. You can maybe get away with it. We are probably going to go up with a FAQ trying to convince you that these other options are not going to work as well.
Another question that has come in. if I file a continuation or a divisional after September 16th, 2012, and the parent case was filed before September 16th, 2012, can I reuse the declaration from the parent case in the child case, the continuation or the divisional? Answer, well, you could file it, but it isn't going to be compliant because it won't contain the magic words that say that it was filed by me or authorized to be filed by me. So yes, you will have to round up fresh signatures from your inventors on a declaration that contains the new language. Did I get that right?
Yes, indeed. You did get right. It's unfortunate, but 115G of the statute says that you have to have 115G deals with copies of declarations. It refers back. It must be compliant with 115A, and 115B talks about 115A, and there is the requirement for that. And there's also the requirement for the penalty clause, perhaps, in there.
Now, having said that, there is a mix of good news with that news that might seem like bad news. And the good news is, because your filing date is on or after September 16th, if one of your inventors is uncooperative or cannot be found, you will have the benefit that you can use substitute statement practice in that newly filed case. And of course, the substitute statement practice will in many cases be easier in terms of the paperwork than the traditional Rule 47 practice that would have been required on a legacy application. Let's take one more question now, and then I'll let Hiram continue. What about entering national phase from a PCT? If I enter the U.S. national phase from a PCT on or after September 16th, 2012, for a PCT application that was filed prior to September 16th, 2012, is the declaration to be used a new language declaration or an old language declaration? And I'll let Hiram take that one.
Thanks. MPEP 1893 something or other makes it very clear that national stage applications is not a new application. It has the filing date of the international application. So the international application filing date is going to govern whether you are need to be compliant with AIA or not. So in this type of situation where you have the international application before September 16th, the deck you file in a 371 case is going to have to be compliant with the old rule. Now, you can get around this if you want by filing a 111A bypass application after September 16th. There is one other question that I had gotten just in my office, and that says, well, we have some of these cases go on for years before we have, 2 years or so before I have to file that declaration in the national stage application. Is the office going to maintain the forms, the old forms, for that long? And I simply couldn't answer that question as to how long we would keep a form, but it's something for you to keep in mind, that you're going to have to keep these old forms just in case we don't have them any longer at the time you might need them.
Thank you. We're going to launch a polling question now. The polling question is one that everybody is invited to try to answer, and the goal here is to learn from everyone what you think the answers might be to this question. Just to speak the question out loud, what are the different ways that an applicant may identify the inventor to the Patent Office under the new rules? And you see the choices there, and we're going to collect our votes here. And I'm just waiting now for some more votes to come in. This is where we find out if we have successfully put everyone to sleep, and the answer is that at least 41% of our audience is not asleep right now. Okay, we've got enough votes here to see a result. Let me go ahead and show on the screen how this came out. And again, the choices were that the inventor's oath or declaration could be used to communicate the inventor list. Substitute statement might be contributing to the inventor list, assignment or application data sheet only. And here's where it's very interesting. Just a few moments ago, we heard that in almost every application you file, you are required to submit an application data sheet, and that the USPTO would take that as the authoritative inventor list in most cases. And yet, having heard that, how can it be that question E is the right answer. And the point is that there is a handful of fact patterns where you would not be required to use an ADS to communicate your inventor list, and you would in fact be free to communicate this by any of these previous things, the oath or declaration, the substitute statement, or the assignment that also serves as the inventor's declaration. So in fact, answer E is the correct answer here. Very interesting question. Okay. Now, pressing on with our presentation, I will invite Hiram to proceed on the pre-issuance submissions.
Okay, thank you, Carl. Pre-issuance submissions is a means for a third party to submit information in the application of another. That final rule also does a couple other things which you might just keep in mind. There are additional prohibitions on facsimile transmissions, and we also have eliminated public use proceedings. But back to pre-issuance submissions. Any third party can make a submission which includes private persons, corporations, government agencies, but not applicants. Applicants cannot use a pre-issuance submission. We define applicants here as 56C parties. This is not, pre-issuance submissions is not meant as a means for applicants to avoid the IDS timeframes and submit information via pre-issuance submissions. Now, the third party on whose behalf a submission is being made can remain anonymous. But to do so, the third party would need to use another as the submitter, in that the submitter must sign the submission. Okay, what can be submitted? Printed publications of potential relevance. What do we mean by potential relevance? Well, potential relevance is not defined by the rule, and I want to make another point here. When you look at these rules, there are actually additional information as to what the rule means if you go to the preamble discussion of the final rule that corresponds to the rule section that you are reading. And if you were to do this in this instance, on page 42-155 of the final rule, it would be explained that potential relevance means the submitter believes that the documents are relevant to the extent that the submitter can provide the required concise explanation of the asserted relevance. I'm not sure that helps that much, but it does make the point that there is additional explanation elsewhere. I just need to know to look for it. Okay. The submission can be made in non-provisional utility, design, plant, and continuing applications, abandoned applications, RCEs. It cannot be made in post-issuance situations. For example, patents. You can't do it in a patent, but think 35 U.S.C. 301. That is an opportunity to provide prior art in a patent file. Can't do it in reissues, but think 291 protests. 291 is still being retained and can be used to submit information in reissues. Reexaminations, you cannot put it in there either. Okay, the submission is for consideration by the examiner. Now, the submission has time limits and must include a concise description of asserted relevance to the publication being submitted. There actually may be a fee. Yes, indeed. We like fees. Now, certain statements are required. A statement of compliance by the submitter with both the statutory and regulatory requirements. Well, why would we do that? To just have someone say that they agree that they have met all the requirements. You don't do that for most other things. Why would we do it here? That's because Congress told us to. They put that requirement in the statute that you must say that you meet the statutory requirements. Well, having that in there, we decided, well, why don't we throw in regulatory requirements too in the statement? So we've done that. You also need a statement that the third party is not a party with a 56 duty of disclosure, because we don't want applicants submitting these statements. Now, the submission may be filed electronically via EFS web. I'm taking another dramatic pause because you have to be careful here. What we don't want happen is we do not want any third-party submissions, nor do we want protests for that matter, to go directly into the file of another until we can determine that it is appropriate to put that information. Here we're allowing a third party to affect what is in the application of another, so we want to be very careful about that. And if you're going to do it via EFS Web, what we have created is a specially designed interface that when you use that, it will tell us that this should not be in the file right away. We're going to collect them in a pool until we give a review of them and an okay, and then they'll be put in the electronic file. So EFS Web can be used with a strong imperative that you must use the interface that is provided with EFS Web, a button or whatever it is you want to think of to do it that way. Okay, the submitter is not required to serve the submission on applicant. We don't want to get into issues of whether there was proper service, which can cause delay, and we don't want to imply that applicant must comment on the submission. Okay, submissions are limited to U.S. or foreign patents, published applications, or other publications, journal articles, office actions in U.S. or foreign applications that qualify as publications, litigation papers and court documents that are publications also. It does not include court papers subject to protective or secrecy orders, trade secret information, and unpublished internal documents. The documents submitted need not be prior art and can raise issues such as enablement or inventorship.
What about something that's just an article on a web page on the internet?
Okay. That's a good point that you're making here, because I foresee that we're going to have a lot of questions in terms of what is a publication. And the answer to your question, so that I can skirt it easily, is tell me if it's a publication or not. If it's a publication, then you can submit it. In fact, I was going to talk about it in a minute. We have the form that we have out there. If something that you're giving us is not clear on its face that it's a publication, we want proof. We want you to attach an affidavit or other proof to us that it is a publication, because if it's not a publication, we're not going to put it in the record. And there is a part on the form that says attachment proof of publication on there. Okay. Let's go on to the time frames. There is a time for submissions, and in the wisdom of Congress, they set it up as an algorithm involving 3 factors. It must be submitted before the earlier of allowance or later of 6 months from first publication or date of first rejection. First publication is not a WIPO publication of the corresponding international application. First rejection is not a restriction requirement or an ex parte quail action. So how to evaluate the time constraints? I'm going to quickly go over 2 different ways to see if it would be helpful to you. Take your choice if you want to use them. First one is start with the later of. So which is later? 6 months from first publication or date of first rejection. Let's presume the later date is 6 months from first publication. Then which is earlier? 6 months from first publication or allowance. The date that is earlier of these 2 will be the bar date. Another way of looking at it is simply to say, well, let's assume there's no allowance, because if there was an allowance, submission would be barred because it's the earlier of an allowance. So if allowance is not there, then all you need is which is the later of, 6 months from first publication or date of first rejection. Whichever of these 2 is later is the bar date if there's no allowance. Okay. Submission contents. Need a list of publications, and as I said before, we have a new form, SB 429, that has that checkbox for a proof of publication. Now, keep this in mind. The list must have a heading identifying it as a third-party submission. That sounds reasonable enough that you would have done it anyway. But also, each page of the list, not each page of the entire submission, but each page of the documents must identify the application. Now, a concise, Description of relevance. What is that? Because that's one of the requirements. You need a statement of facts of how the document is of potential relevance to examination. How do you go about establishing the relevance to that? Well, you can tell us how the elements of a claim are met by a particular publication. You can even use a claim chart. But this is different from the concise explanation. A concise description under 290 of third-party submissions is different from the concise explanation permitted as a protest under 291. The concise description cannot amount to a protest. For example, arguments against patentability could amount to a protest. It's going further than just telling us what's in the claims and what's in the reference. Now, there is a fine line here as to which side you might be on, but keep in mind that unlike IDS's, non-compliance of any single 291 citation means kaput for the entire submission. If it fails in any one of the items you're giving us, the entire submission fails. Okay, one of the other requirements is you need copies except for U.S. patents and published U.S. applications. You must give us a translation of any non-English language document. Now, both the copy requirement and the translation requirement is for as much of the document as listed. An entire document should not be listed if, for example, it is a textbook and only one chapter is relevant. The general rule, however, is we would like the whole document. If it's a journal article, we want the whole document in terms of the journal article, at least for context. But if it is a foreign language, you're going to have to translate the entire journal article. Okay, one of our favorite topics is fees. So here we are, $180 for every 10 documents identified in the list. We go down the list of items that you've given us and we start counting. How many are there? Any fraction of 10 is going to be $180 too. So if you give us 8, it's still going to be $180. You don't get any prorating here. Now there's an exception to that. For a first submission of 3 or fewer, that is free if you give us a statement. And what the statement has to say is that this submission is the first and only submission. The reason for the only part is that to prevent 2 submissions on the same day, both having 3 items. Now, the statement of only is not going to prevent a subsequent submission provided, and this is found on 42158 of the final rule, another preamble discussion, where the need for the subsequent submission was not known at the time of the earlier submission. So if you're thinking, well, I've got 6 and I'm going to give you 3 free now and I'll get the other 3 in, that does not comply with the essence of what we want you to tell us, the first and only. Now, more than one submitter can take advantage of the free exemption so long as privity does not exist among those submitters. Okay, we have processing flow chart. A compliant submission is, of course, made of record in the application. Applicant will be notified if applicant participates in the e-office action. There is no requirement, as I said before, for applicant to reply, although we have a caveat in there, absent an office request. The office envisions that perhaps some of this information may raise issues that we may want to ask the applicant about, and if we do, we'll ask you about it, perhaps in a 105 requirement for information. Absent that, we don't necessarily want to hear from you. Non-compliant submissions will, of course, not be made of record. The third party will be notified of the non-compliant submission if an email address is provided, there will be no time period for correction. However, you're free to correct it just as long as the statutory period, which continues to run, has not expired by the time you get the correction in. Now, you cannot amend a non-compliant submission. We want everything submitted again because we're not putting the first one in, and we don't want to cut and paste, so you have to give us an entire new one. Okay, we have a compliant submission. The publications that are identified and their corresponding concise descriptions will be considered by the examiner as would documents listed in an IDS. Examiner consideration will be specifically indicated on the document list. Considered documents will be printed on the face of the patent. Now, the office is in the process of upgrading its IT, so to be able to differentiate applicant and third-party submitted information. I don't know what the time frame is for that, but that is our intent. And that was what was suggested by the public in their comments, that they would like that to have those differentiated, and we are going to try to do that. Now, it's important to keep in mind, particularly for applicants, that examiner consideration does not equate to agreement with the description provided by the submitter, and we're going to try and make that clear somehow. Third party is not permitted to respond to an examiner's treatment of submission, no matter what their visceral reaction is. Personally, I will find it interesting to see how submitters will try to skirt that prohibition with subsequent submissions if they become enraged about what the examiner has done or not done, but that's a matter for another day. And the last thing is just a chart of a summary, so I will skip that.
A couple of questions have come in. One of the people who's attending our program has asked, suppose an application was pending before September 16th, can I, as a third party, do a submission of this kind after September 16th in such an application?
The general rule here is, and we have up front, if you take a look at the final rule, there is, like on the first page, a whole list of rules as to what is applicable before or after. The general view of things is things that are mandated by the AIA are going to be apply to applications filed on or after. So I don't recall specifically, I think this probably will not be applicable depending, but I don't know for sure. I don't know if Carl has an idea, but the general rule is that if it's mandated by AIA, it's only for applications filed on or after but there are other changes in the rules that were not mandated that will apply to other applications. I would really, to be 100% certain, I'd have to take a look to see what it says. Now, so I think on the cover, let me just think the cover slide. I think we have may have some indication on that. Pending or abandoned file before, it's for everyone. There we go.
Okay.
We already have it on the sheet.
How about that? And that's slide number 15, by the way.
So you never heard what I said.
One of the things Hiram said, though, is important to keep in mind. Of the rules changes that we see in the August 14th rules package, some of them apply to any application regardless of filing date, so long as the thing that you're about to do is something that you're doing on or after the 16th. There are other things that can only be done on or after the 16th, and they can only be done in an application whose filing date is on or after the 16th. Just now, looking at slide 15, I see that you can do one of these submissions even in a case that was pending before the 16th if you satisfy all the other timeline requirements. Another question that has come in is whether the filing of an RCE would restart and reopen opportunities for filing one of these submissions.
You can file them in RCEs, but there's no such thing as a restart. It's whatever statutory bar would be in there in terms of whether there was a publication, whether there was a first, obviously there was a first rejection in there, so it would be notice of allowance or the publication would govern in those. You don't start from scratch.
Okay. Now, I'll just throw in a practice tip here. One of the slides that Hiram presented talks about how if you are an applicant or your counsel representing an applicant, and if somebody files one of these submissions, how will you even know that it happened? And the answer is you're not going to hear about it directly from the Patent Office unless you happen to be signed up for the e-office action system. And so the practice tip here is make sure every one of your active cases is in the e-office action system, because otherwise one of these things could happen and you might never know that it happened until by accident you stumble upon it by clicking through IFW or something like that. Okay, well, let's press on to our next section, supplemental examination.
Okay, thank you, Carl. I'd like to start off with some terminology. Supplemental examination, what is that? It actually consists of two parts. A supplemental examination portion to determine the existence of a substantial new question of patentability, an SNQ, and the second part, which is any ordered ex parte re-exam if an SNQ is found in the supplemental exam portion. So the term supplemental exam means two things. It means supplemental exam and ex parte, the whole process, and it also means the first portion of the supplemental exam whole process. Okay. Now, SNQ, for those of you who hear that term and not quite sure if there's a definition for that, we have that in the manual 2242, where there is a substantial likelihood that a reasonable examiner would consider the item of information important in determining patentability. Sounds awfully like the old Rule 56 language, but there it is. The final rule sets fees. The final rule for supplemental exam does three things. It has supplemental portion and it has two other portions. It sets fees for ex parte re-exam that is not an ordered re-exam out of supplemental examination. And it also sets fees for petitions in ex parte and inter parte re-examinations. The petition fee is $1,930 now. Now that's my kind of money for just saying no. So we have an extra things that this rule has done. Okay, so moving back to supplemental examination. The supplemental examination can only be requested by the patent owner in regard to its patent, to consider information never considered, to reconsider information previously considered, or to correct information previously considered in regard to the application resulting in the patent. Now, the patent owner must establish ownership under 3.73c. So, a third party cannot request or participate in a supplemental examination. The request for supplemental examination may address any condition of patentability, for example, 101, 102, 103, 112, double patenting. The information supplied to address these issues is not limited to patents and printed publications as third-party submissions are, but may include such things as transcripts of audio and video, affidavits and declarations, exhibits. Now, why would a patent owner want to file a supplemental exam? Well, for example, the patent owner wants to sue for infringement, but is fearful of facing a defense of inequitable conduct based on some information newly found in their file, but inadvertently not submitted to the office during prosecution of the application. The newly discovered information submitted to the office and considered in the supplemental exam cannot by statute be the basis for rendering the patent unenforceable. A supplemental exam can be submitted at any time during the enforceability of the patent. What is that, enforceability of the patent? Well, it's the date of expiration plus 6 years. Now, please don't call. The office will not comment or advise on the expiration date of any patent. There are too many considerations, such as PTA time, PTA deductions, terminal disclaimers, disclaimers in general. So office personnel will not comment on when a patent is to expire. Now, there are two exceptions when immunity will not attach. If the supplemental exam is not filed quickly enough or completed in time, there are a couple examples that one could talk about, declaratory judgments or infringement suits, but we're running a little short, and this is not something that the office does, so I'd rather not put it out there and talk about those. But there are a couple examples. Well, declaratory judgment is brought against the patent owner by a plaintiff fearing an infringement suit. They make allegations by a plaintiff regarding certain information, and they're pled with particularity. It may be too late to file a supplemental request. There's another one where the PO, on the other side of the coin, where the patent owner sues an alleged infringer. There's a defense of inequitable conduct that can be raised, and if you have on information, now if that information is in a supplemental exam or ordered re-exam that is not completed, that defense may still be good. You may have to complete that before to bar those type of attacks. Anyway, moving quickly away from that, since that's not our subject of expertise, and on to the next slide. The request can be filed by our EFS web. But, again, I'm taking that pause here, just like I did with third-party submissions. There is a specially developed interface, just like third-party submissions, so that we can examine whether the supplemental request is appropriate. You're not attacking someone else's file, but we still want to review that. One of the reasons is one of the reasons that's driving a lot of these things is there's a statutory requirement that they do these things in 3 months. They do the first portion to decide whether there's an SNQ. So they're trying to arrange things like denying filing dates if there is something that's incomplete. They're not going to give you an opportunity to fix something and draw something out. They're going to say you have no filing date. So when you come back with it, then we'll give you a filing date, and that's when our 3-month period is going to run. So keep that in mind. You cannot file these papers by facsimile. That's one of the changes to facsimile transmission practice that's being made. We have posted a supplemental exam form. It covers a Part B that has a list of items of information.
Let me just ask, from the Patent Office's point of view, would there be a preference as between paper filing or EFS web filing?
Oh, absolutely. We would like electronic filing because we may have to give you a filing date as of the paper date, and if we don't process those in time, it's going to cut down the amount of time that we'll have to take a look at it. So, okay, content requirements. You need to identify the patent and supply a copy of the patent and any of the disclaimers that might go along with the patent. You also need to identify each claim for which supplemental exam is requested. Now, don't overlook this. As I said, there's a 3-month requirement that we meet in terms of making a decision on this. The office will limit its activity generally only to what is specifically raised. So if you're going to leave out a claim, we're not going to add it for you in terms of what the consideration is. A list of items. You have to give us a list of items of information. There is a limit of 12, up from 10. With the number treated is the number that is on the list as to how many items you have in there. But I invite your attention to pages 48, 833 to 34 of the final rule as to how the office counts items. I'll give you a couple examples. A foreign language item requires a translation of all necessary and pertinent parts. Now, this is different from third-party submissions where we want a translation of the entire document cited. Here, we're willing to take a translation of all necessary and pertinent parts, and both will only count as one. Yet, a declaration relating to a public use or sale having one exhibit relating to 2 separate instances counts as 2. They're separate instances. We also, okay, enough for how we count. As I say, I invite your attention to that. It's kind of interesting in terms of the distinctions that we make there. A detailed explanation of the relevance and manner of applying each item to each claim. We want you to follow the practice set forth for ex parte re-exam at MPP 2214. Now, for documents over 50 pages, Now, we're not talking about the request now, but other documents, over 50 pages. We want a summary of the relevant portion, which with page citations. Okay, slide 29, fees. All I can say is read them and weep. Wait, there's a smidgen of hope. There's going to be a Section 10 study. Stay tuned. Okay. If an S&Q is raised, the office must order ex parte reexam, which is the standard ex parte reexam we've all come to know and love, except that there is no patent owner statement, and the issue raised may be broader in view of the broader issues that can be brought up in supplemental exam. Interviews and amendments must wait until the ex parte reexam portion. But phone calls regarding receipt of the request and general procedural questions are not interviews. If an SNQ is not found, ex parte reexam will not be ordered, and there will be a refund. Okay. Now, supplemental exam will conclude with electronic issuance of a certificate, and the certificate will indicate whatever happened. And I think I'm done with that topic.
Okay. In a moment, we will turn to Judge Lane, and but first I have a couple of questions for Hiram. Do you know when a new CFR showing the contents of the new rules will get published on the USPTO website?
I haven't a clue, but, you know, maybe that's a good FAQ. We'll work on that. I use a green book, I guess, for the statute anyway. I think there's, for the manual itself, which includes the CFR, they're coming out with a new revision shortly, within a few weeks. And then the next thing after that is not going to be a revision, but it's going to be a new edition. And in fact, I take it, I'm not going to even put out an FAQ on that because they're having problems with the software now that they think they're getting ahead of the curve on that, and we're just going to have to wait and see.
Of course, one of the things is, for example, the Rule 63 that would apply will be a different Rule 63 depending on the filing date of the application. So for any practitioner, there is no single Rule 63 that would control your life starting on September 16th because it would depend on the filing date of the application. And there are many, many other examples of situations where you simply have no choice but to keep your hands on old and new rules both.
It's just like the statute, 102E. We have a new statute and we have an old statute.
That's right. That's right. Okay. Thank you, Hiram. We'll come back to you when the question period comes around. But now we have Judge Lane, and we get to hear about some of the administrative things.
All right, thank you, Carl. Good afternoon. So I'm going to talk about the new proceedings that we'll be conducting at the soon-to-be Patent Trial and Appeal Board. Today I'm just going to refer to it as the board because that's what I'm used to. Our final rules for the new proceedings published in mid-August, and we look forward to their effective date in just a short while. We received a lot of useful comments from the public before and after publication of the proposed rules and the proposed practice guide. So as I go through the slides, you're going to see these areas of blue, and I want to point out to you that those are areas that we made changes from the proposed rules. And those were modified or clarified in view of the comments that we received from the public. So as you can see, from the first slide, there are 4 new types of proceedings that the board will be conducting in accordance with the AIA. Fortunately for all of us, there's much commonality in the statutes mandating these proceedings. So we've been able to come up with a set of umbrella rules which will guide all the proceedings. So all 4 the inter partes proceedings, which I today will be referring to as IPR, the post-grant review, which today I will shorten to PGR, the covered business method review, which today I'll shorten to CBM, and then the derivation proceedings. Now, I want to point out that the derivation proceeding final rules have not yet published. So really this slide should say proposed 400 through 412. I also, when I'm discussing derivation today, it'll be limited to where it is referred to in the umbrella rules. So I'm not going to be discussing what is in the derivation proceeding proposed rules. I also want to point out at the top of the slide we say AIA Trial Proceedings. A trial by definition doesn't occur until we've actually initiated a trial. The proceeding begins upon the filing of a petition, so I just wanted to clarify that. Now there are some peculiarities of each proceeding, and as I go through the slides I'm going to discuss each proceeding separately. Fortunately, mostly they're really a lot alike, so the discussion is fairly easy about the differences. And then as I progress through the presentation, I will end up with the umbrella rules and go through those near the end of my talk. So this is a timeline that we've come up with to illustrate how we expect the proceedings to work. So each proceeding will start with the filing of a petition, and this is for, I should clarify, for PGR, IPR, and CBM. This would not be the same timeline for derivation. So each proceeding will start with the filing of a petition. And the filing of a petition will trigger the time for the patent owner to file a preliminary response. Now I'll talk about this later, but this is not going, we don't expect this to be a full-blown response with a lot of evidence and testimony. We expect this mainly to focus on standing issues and failure to meet the threshold for whichever proceeding the petition is directed toward. As you see, we plan to get a decision on whether to institute to the parties within 3 months of the time the patent owner response has been filed, or if no response is filed or it is due. A patent owner need not file a response. We expect that most will, though. We are at this time hopeful that we can get some of these decisions on whether to institute or not to you even in less than 3 months. Now, if a decision to institute is made, at that time we'll send out a scheduling order, and the goal of this scheduling order is to help us complete the trial in 1 year, which is, of course, what the AIA has told us we should do. So the schedule after institution will look something like this. Within 3 months after, the patent owner can file a full-blown response at this time. So we're talking about a response that would have any evidence that they would like to file and likely will rely upon testimony. The patent owner also could file a motion to amend, substituting a reasonable number of claims. After that, there's another 3-month period that begins. And may I say that at some point after initiation, we will have a conference call with the parties. So there'll be a chance to iron out any issues that are arising, perhaps discovery issues, perhaps a discussion on what a reasonable motion to amend would look like.
Who would be likely participant for the board in such a conference call?
We expect that when the petition arrives at the office, immediately it will be assigned and receives a filing date. So as long as those the requirements for a filing date are met, then it will be assigned to an administrative patent judge, and that judge will oversee the case and perhaps, and my expectation is we will even have a panel assigned at that point so that you will, even if one judge is not available, there'll be a backup judge so that you could always have someone to call if you need an order from the judge or some clarification after the petition is filed. So after the motion to amend, then this will start another 3-month period. And during that 3-month period, the petitioner will be preparing their reply to the patent owner response, as well as any opposition they wish to mount to the patent owners, if there was one, motion to amend. Thereafter, another 1-month period will begin, and this will be a time for the patent owner to file a reply to the petitioner's opposition to any motion to amend. Finally, we'll have a 2-month period, and during that 2-month period, while it's not laid out here, there'll be motions to exclude. There may be more cross-examination based on that reply, and there may be a chance to file observations on that cross-examination. Then if the parties request one under the AIA, they may have an oral hearing, so we'll schedule that. And then that leaves us no more than 3 months to get this decision to you. And again, our very clear goal is to get this done in 1 year. There is a provision in the AIA that allows for an extension of up to 6 months for good cause, but at this time we expect that to be a very rare instance. We expect to have these done within 1 year. Now keep in mind that while all this is going on, these 3-month periods may sound like a lot to prepare some of these papers, but this is a time when discovery will be occurring, and particularly cross-examination of the witnesses whose testimony is relied upon in the papers.
A question has come in that I thought I would ask at this stage. How much discretion will be available to the patent judge to dismiss the trial, assuming the petitioner and the patent office somehow come to an agreement, that is to say, settle the case? Is there intended to be a settlement mechanism, I guess, is sort of the question.
Well, certainly the AIA provides for settlement after a trial has been instituted, and you're talking about before that has even occurred. At that point, I'm certain that we would entertain, as has been our practice, to encourage settlement. I'm certain we would entertain that proposition. It would be a good time to call a judge and find out how that would work. But I would see no reason why we would not entertain that. Okay, what I'd like to do now is talk about the major differences between inter partes review, post-grant review, and the covered business method patent review. So not all patents are eligible for all types of review. However, all patents are eligible for IPR. Only those patents which are first to invent patents are eligible for PGR, so it's likely that it'll be some time before we actually start to see these PGRs. CBM applies to both first to file and first to invent patents, but only if the patent is a covered business method patent, and I'll talk more about what that means later on. For IPR, we'll not institute a proceeding if the petitioner has filed an invalidity action. Also, the petition must be filed no more than 1 year after service of any infringement complaint against the petitioner. Now for PGR, and it's only available 9 months after issuance, and within the first 9 months after issuance, there's only a requirement that the petitioner has not filed an invalidity action. For CBM, the petitioner has to be sued or charged with infringement in order to file the petition properly. Finally, there's a difference in the grounds of unpatentability that may be asserted for each proceeding. As you see, for IPR, only 102 and 103 grounds may be asserted, and they have to be based on patents or printed publications. This is not to say that testimony couldn't come in to explain what the printed patent or printed publication would say to one skilled in the art, but testimony alone could not be a basis. For PGR, as well as CBM, the petitioner may assert grounds under 101, 102, 103, and 112, except best mode is excluded from 112. So when will the board institute a proceeding? The petitioner is going to have the burden of proof, but there is still a difference in what must be shown between IPR and PGR and CBM. So IPR has one standard, and that standard is that the petitioner must demonstrate a reasonable likelihood that petitioner would prevail as to at least one of the claims challenged. And PGR and CBM, that's a different standard, and the more likely than not standard. In other words, the petitioner has to demonstrate that it's more likely than not that at least one of the claims challenged is unpatentable. We did have a lot of comments as to asking for clarification. What does that mean? And what is the difference between these standards? So we tried to do a little visual there. So for PGR and CBM, it's a higher threshold. It's a greater than 50% chance. So I think of it like preponderance. For IPR, we feel that it may encompass a 50-50 chance and maybe something a little less than that. Okay, so this slide is meant to illustrate the difference between the treatment of first-to-invent patents and first-inventor-to-file patents. In particular, for first-to-invent patents, that is all that are out there now, they may be subject to CBM after issuance or to IPR 9 months after issuance. So for IPR, as of September 16th, it still will work only for those patents that have been out there for 9 months. For first inventor to file patents, so those issuing under the new system, those will be subject to PGR for the first 9 months after the patent is issued. Those patents also still will be subject to IPR or CBM, but only 9 months from the issue date, or if there has been a post-grant review, after that post-grant review has been completed, the later of those two.
Oh, yes. Thank you. Yeah, we have a polling question here, and the purpose of this is, once again, to check and make sure we have not put everyone to sleep. Let me go ahead and select the question and put it on the screen. All right, about 1/4 of our people have voted and thus have demonstrated that we have not put them to sleep, or at least that they woke up again when they heard a different voice, or both. Okay, we've gotten about half of our votes. I'm going to go ahead and post results here. And 96% of our attendees said that answer E was correct. What is your reaction?
It sounds like that's a smart group then. That is correct. The umbrella trial rules apply to all of the above, and as I mentioned, that is something we were able to do because there are many commonalities in the statutes between the proceedings, so that worked in our favor. Okay, now I would like to focus specifically on inter-parties review for a bit. As I've mentioned, all patents are eligible for the inter-parties review. However, there are some limitations as to who may file a petition. First of all, the petitioner cannot be the patent owner, and that's true for any of the proceedings. He cannot have previously filed a civil action challenging the validity of a claim of the subject patent. Also, the petition must be filed no more than a year after any complaint of infringement of the subject matter was filed against the petitioner. Again, as I mentioned earlier, the grounds for challenging the claims are limited to 102 or 103 grounds and must be based on prior art that is a patent or a printed publication. Again, as I mentioned, the petition cannot be filed until 9 months after the grant or reissue of the patent or the date of termination of any post-grant review of the patent, and whichever of the later of those is. So basically, we would not start an IPR review, even though it's 9 months after the patent had issued, if there's a PGR ongoing of the patent. So there are certain requirements of the petition. If you look beside the print here, you'll see that some of them are by rule and some of them are by statute. If it's a requirement of the statute, such as the fee, then we will not accord a filing date until that is complete. So, of course, we put this number 1 again with the fee. It must be accompanied by a fee. Must identify all the real parties in interest. Now, this is very important for the board and for the parties. For the judges, it's important because we need to evaluate whether we have a conflict. For the parties, it's important because they need to evaluate whether there's an estoppel. Also, another requirement is all the claims that are challenged and the grounds on which the challenge to each claim is based must be identified. Another requirement is claim construction, and we did get a lot of comments on this requirement. You have to provide a claim construction and show how the construed claim is unpatentable based on the grounds alleged. We're going to be using the broadest reasonable construction. How much needs to be given here is going to vary on the facts. So there will be situations where it would be sufficient to say the board should give these claims the broadest reasonable construction. Other times where the party is aware that claim construction is a big issue and how this review will whether the review will be instituted and what would happen later in the review, it would be a good idea to give a more extensive claim construction. And that may just be true for one of the terms in the claims, but for that term, if you know it's going to be a problem, you may want to go ahead and give a more robust claim construction. You're also going to have to provide copies of the evidence relied upon and certify that the petitioner is not stopped from proceeding, for example, because of another judgment within the office. So as I said before, after a petition is filed, the patent owner, after having seen the petition, then has an opportunity to file a preliminary response. The response will be due 3 months from the filing of the petition, and I'll note that is a change. Originally we had this set for 2 months in the proposed rule and practice guide, and we have changed that to 3 months. So the response would be due 3 months from the filing date of the petition, and it should explain why the petitioner did not make a sufficient showing to warrant initiation of the proceedings.
That 3 months is non-extendable?
That it's by rule, it's not by statute, so we could waive that time frame. Now, why would we do that? There'd have to be a reason. One of the things I could think of is if there was some dispute as to whether a party had standing, and then perhaps some discovery would have to be taken, and at that point, the judge could say, yeah, 3 months is not going to be sufficient for you. So that is an extendable time, unlike the time that the board has to act on the petition and the response. This time is extendable because it is not by statute. So the patent owner need not file a response for the petition to be denied. That could still happen even though the patent owner did not file a response. We expect most patent owners will file a response, but they don't have to. The patent owner can inform the board that it does not intend to file a response in that case, and that would be useful to us, but they need not do that, but it would be nice. Ordinarily, a patent owner will not be permitted to rely upon testimonial evidence. This is a change or clarification from our proposed rule you see in blue. If a patent owner shows it's in the interest of justice to allow the evidence, the board may permit testimonial evidence. One example, as we were talking about earlier, would be for standing purposes. For example, to show that the petitioner is stopped from challenging the patent claims. In such an instance, and you can see the practice guide for more about this, but in such an instance, the patent owner will need to contact the board and seek authorization before they could submit this testimonial evidence. So again, the threshold for institution of an IPR is reasonable likelihood that the petitioner would prevail as to at least one of the claims it is challenging. If after considering the petition and any patent owner response, preliminary response, the board concludes that the threshold is met, a trial will be instituted. The trial may not be instituted based on all the challenge claims or all the bases on which the claims were challenged, though. So as the slide says, it would be a claim-by-claim and ground-by-ground decision. It may be that a trial is instituted for only one or some of the claims that were challenged and only one or some of the bases the petitioner used for the challenge. This is a change. In blue, you see that if a party is upset with our decision to either institute or not institute, then that party may request rehearing.
What do you think the chances are that a rehearing would get a different answer than the first decision?
Well, interestingly, if we do panel in threes for the first decision, then probably less likely because it won't be three people taking a look at something only one person was looking at before. But having said that, even a panel of three can overlook something. So I wouldn't put a number on that, but certainly I can't say it never happens. So the trial will be completed, as I said before, within 1 year. That is in the statute and our rules. And again, as I mentioned, we can, the director can, not me, the director can extend the time for up to 6 months for good cause. We do not expect that to occur very often. So now I'm going to talk about the patent owner response. And this is the full-blown response, not the preliminary response that I was talking about earlier before institution, where maybe there wouldn't be that much evidence and that much testimony, if any. This is the full-blown response. So this response, usually, as you remember from the timeline I showed you earlier, it usually will be due within 3 months of institution. A time other than that may be set by the judge or modified as circumstances may warrant, and this would be something to discuss at the conference call. As I said before, a scheduling order will go out when we institute. It's likely that a party is going to realize right away that there's an issue with the scheduling order. So judges will always be available to take these calls about issues that you're having with time or, discovery, these types of issues. So it may be that the schedule that you're given upon institution will have to be adjusted. That would be a good thing to talk about at the initial conference call, which will occur within a month of the institution, though, if possible, if it can wait that long. So the response should address the claims and bases upon which the trial was instituted. So this perhaps will be a more narrow response because it's possible that the trial was not instituted based on all the grounds and as to all the claims that were attacked. This response can include all the evidence that you may not have put in your preliminary response, and it also can include testimonial evidence concerning facts or expert opinions. The patent owner can move to amend the claims once as a matter of course. That is in the AIA. Conferring with the board is necessary first, however, because we want to discuss the timing and the number of substitute claims that the patent owner wishes to present. We also would like probably to get an idea from the petitioner to see if perhaps once this claim is amended in a certain way, the petitioner would agree that there's no longer a patentability issue. And we may want to talk to see if the petitioner is going to oppose that motion. There's actually a chance that a patent owner could file an additional motion to amend. We don't expect that to be a frequent occurrence, but we do have a provision for that, and it would be under a good cause standard. One example of where we may allow an additional motion to amend is where we have let supplemental information come in belatedly. Another situation where we may allow an additional amendment is where the parties are settling and an amendment will facilitate that settlement. Because the time for completion of the trial is short, it's important for the board to prevent abuse of the amendment process. So that's another reason we want to talk about these before you file them.
A question that came in might be timely here. If the board denies an inter-parties review, what is the appeal or review mechanism for that denial? Appeal or review mechanism above the board, I guess, is the question.
Oh, above the board, there's no appeal. At the board, again, there's a rehearing, but if the petition is denied, then there is no appeal beyond the office. Now I'm going to talk a bit about post-grant review. Fortunately, and many aspects of post-grant review and IPR are effectively the same. So this will be a shorter discussion than that on IPR. I'm just going to highlight some of the important differences between these two types of review. First of all, only patents that issue from first inventor to file applications are eligible for post-grant review. So that's why we don't expect to see those for a bit. Another difference is that there are more bases upon which the challenge can be based. Again, 101, 102, 103, and 112, except for best mode. PGR can only be requested within 9 months of the date the patent issues or reissues. And the standard, the threshold, is different. The petitioner here is charged with demonstrating that it is more likely than not, which is a higher threshold than IPR, that at least one of the claims challenged in the petition is unpatentable. Okay, now I'm going to move on to the covered business methods. CBM proceedings are basically just a specialized kind of PGR. So they employ the PGR standards and procedures with certain exceptions. Again, I'd like to highlight some of those differences. First, there's an issue of when a CBM review may be undertaken. A petition should not be filed if a post-grant review is available, essentially. For example, the first inventor to file patents, in the first inventor to file patents, a petitioner should wait until 9 months after issuance of the patent, or if later, the time that the PGR has been completed. For the other patents, the first to invent patent, CBM, is available as of September 16th. Another major difference is that the petitioner must be sued or charged with infringement to properly file a petition. Because CBM requires a patent that is a business method patent, the petitioner has the burden of explaining why the challenged patent meets the business method patent test. There also is a limit as to what prior art can be used to challenge a first-to-invent patent, and that is set out at Section 18 of the AIA, so I would ask you to refer to that. So all patents are eligible for CBM review so long as they are covered business method patents. So both first inventor to file patents and the patents issuing under our current system are eligible for this CBM review. So the AIA provides that to be a covered business method patent, the patent has to be directed to a method or corresponding apparatus for performing data processing or other operations for a financial product or service. However, there's an exclusion, and patents that are for technological inventions are not considered to be covered business method patents. So now I'm going to move to a discussion of our umbrella rules. And these are the rules that I spoke about earlier that apply to all the new proceedings. And they give us a nice framework for handling many basic aspects of the new proceedings. In all the proceedings, identification of the real party and interest is required. I think I discussed the importance of that earlier, so I won't go through it again, but I will tell you that if there's any confusion about who the real party is, we give a pretty good discussion in our practice guide, and that provides some factors for consideration when you're making your determination, and kind of lets you know what we'll be looking at when we're trying to decide if you've properly identified the real party and interest. Additionally, we're going to require each party to provide some basic information, which really should not be a big deal, but you need to tell us your lead and backup counsel and some contact information, at the minimum one email address and one phone number so we can contact you.
Okay, we have a polling question here, and this, once again, reviews what we have just been talking about. Oops, let's see here. There we go. All right. Now, unfortunately, the limitations of our webinar system did not let us put in 6 possible answers. So the what you're going to vote on is 5 possible answers, the last of which is A, B, and D. And okay, we have enough votes, I think, to pull a trend out of this. Virtually everyone is choosing the last choice, the A, B, and D choice. And with that in mind, I'll just display what we just got. We'll just take a moment for that to come up on the screen. Yeah, virtually everyone chose that last choice, and I will invite Judge Lane to comment on people's giving that answer.
I think we're going to have to come up with trickier questions is what I think. It seems like you guys all got that right. Yes, there's no requirement that you provide a clean copy of the challenge claims, but all those other things are required. So moving along, in our proceedings, I mentioned that you need to tell us lead and backup counsel. So that is a requirement. You're going to need to provide someone who's your lead counsel and someone who's the backup counsel. Here's a change from the proposed rule. The lead counsel is going to have to be a registered practitioner. So what's the big deal about that? Well, the board is going to provides now that counsel may be recognized pro hoc vice for the proceeding alone. But this person, if recognized pro hoc vice, cannot act as the lead counsel. So whoever's on the hook as lead is going to have to be a registered practitioner. Now, to be recognized pro hoc vice, we're going to have to file a motion, and it's going to be granted upon a showing of good cause. The person who is applying for the status will have to agree to be subject to the office's code of professional responsibility, and the board may impose some other conditions depending on the facts. For example, so when would the board entertain this? One example is when counsel is an experienced litigation attorney and has familiarity with the subject matter at issue. Suppose they've been working on this in other arenas, this particular matter. I would also say, in addition to that, that the person would have to have some level of patent knowledge, or at least say that they're trying to gain that knowledge.
A question that just came in seems timely. Lead counsel must be a registered practitioner. Could that person be an agent, that is to say someone who is not an attorney but is nonetheless registered to practice before the USPTO?
My understanding is that you cannot be an agent, that you have to be an attorney. So also just a note, and this is not the most pleasant thing and nothing we expect, but at the bottom of that slide it does mention that your pro hoc vice status could be revoked for those reasons. Again, this is not something we expect to see much of, if at all. Now we get to talk about fees. So I've set out here what the fees are for the different proceedings. This is in blue because we did make some modifications. Originally, the base fees themselves did not change, but what did change is how we calculate the fee beyond the first 20 claims. So rather than have these blocks and make the fee go up much more for blocks of claims, people seem to prefer this claim-by-claim escalation. So for IPR, there's a base fee, and then there's $600 for each additional claim above 20. For PGR and CBM, there's a base fee and $800 for each additional claim above 20, and then you have your bargain there with derivation. The reason the IPR and PGR CBM fees are what they are is because the AIA requires us to base them on the aggregate cost to the office. Again, there was earlier discussion about the fee setting authority changing, and there is a chance that we'll change this to more of a staged fee, essentially to provide a refund of the fee where proceeding is not initiated, but not a portion of the fee, certainly not the entire fee. So this also in blue, this is a change from the proposed rule. The page limits have been extended, increased by 10 pages for all of the major filings. So now for IPR, we're looking at 60 pages for the petition, preliminary response, and patent owner response. For PGR and CBM, we're looking at 80 pages for the petition, preliminary response, and patent owner response. And for derivation, we're looking at 60 pages for the petition and opposition. The other thing we did to help out with these page limits that seem to be troubling folks, we've allowed that if you are going to submit claim charts, you can do them using single spacing, so that should save some space. We did have a requirement for the statement of material facts, and now we've changed that to an option. I would say that in certain situations, statement of facts are really useful, and in certain situations they're not, so that would be a judgment call when you're drafting these papers. Now I'm going to talk a bit about discovery. The AIA authorizes the office to set standards and procedures for the taking of discovery, and we have done so. We've tried to make it clear in the final rules that parties are allowed to agree to discovery between themselves. And we're going to be pretty permissive about that. If you all want to exchange information, have at it. We're not going to stand in the way of that. We also have a provision for mandatory initial disclosure. So this is actually something, a list that the parties can agree to. In addition to the routine discovery, and there's also a way for the parties to ask for additional discovery. Also would be a way, if one party wants to make the mandatory initial disclosures and the other does not, for a party to move and ask that both parties be required to, there would have to be a good reason provided for that. So the main type of discovery that we expect to see in every case initiated is routine discovery. This will include documents that are cited in the parties' filings, cross-examination of witnesses, and revelation of information that is inconsistent with the position taken during the proceeding. Now again, this was the inconsistent statement provision in the proposed rule. We did receive a lot of comment about that. So that rule has been modified to limit the scope and the number of individuals that are subject to the rule. So as I mentioned, the parties may agree to additional discovery. Yes, I did. As I mentioned, the parties may agree to additional discovery, and my current experience is that parties often cooperate in this way, at least on a limited basis. However, if the parties do not agree, then the party seeking discovery must confer with the judge and request the discovery. Of course, the routine discovery I discussed earlier is always authorized. There are different standards we're going to use in determining whether to authorize additional discovery based on what proceeding we are in. For IPR, we're going to use an interest of justice standard, but for PGR and CBM, we use a lower standard, and that is the good cause standard. So supplemental information again. A party may request to provide supplemental information within the proceeding. The rules require that a party that wants to file supplemental information needs to come in within a month after institution of the proceeding and ask to submit the supplemental information. Now, it's only going to be allowed to come in if it's relevant to a claim for which the trial has been instituted. In particular, it would not be appropriate to submit a reference pertinent to a ground of unpatentability unless the trial was instituted based on that ground. So you can't come back and kind of get a do-over and say, I wish I'd put this in. And then you would have granted my petition. No, it's only going to be based on what actually was the basis for the institution. There is a provision for a party to ask to file supplemental evidence belatedly, but the party is going to have a pretty high threshold to have us do that because it's kind of late. You know, we don't like people, even the appearance that people are lying not being forthcoming with this information as soon as possible. So what we're going to ask you to do, if you're in that situation, you're going to have to show why the information reasonably could not have been obtained earlier, and you're going to have to meet the interest of justice standard. So both the petitioner and the patent holder will have estoppels against them after a final written decision, not prior to institution. So first I'm going to discuss the petitioner estoppel. Before the USPTO, there are certain estoppels for IPR, PGR, and CBM. The petitioner cannot request or maintain a proceeding with respect to any ground that was raised or reasonably could have been raised within the trial. So that's before the PTO. Now, before the district court or the ITC, a petitioner in IPR, PGR, CBM review cannot assert a claim that a claim is invalid on any ground the petitioner raised in the trial. For IPR and PGR, the estoppel also extends to any ground that reasonably could have been raised during the trial. There's also, as I mentioned, a patent owner estoppel that applies after final written decision. This is all in blue because this was modified to be lesser in scope than what was in the proposed rule. These actions would be a patent owner cannot take action inconsistent with the adverse judgment, and those actions might include obtaining in a patent a claim that is patentably indistinct from a finally refused or canceled claim. Also, the patent owner could not come in and amend a specification or drawing that was denied during the trial. So, but this provision will not apply to an application that has a different written description. But if you're going with a continuation that has the same written description and you ask to amend before the board and the board said no, then you're not going to be able to skirt around that by doing it when you're back before the examiner. And again, at the bottom, I think we just point out that the proposed estoppel provisions as to claims that could have been presented, that was in the proposed rule, but it was not adopted in our final rule.
Thank you, Judge Lane. Let me read a couple of the questions that have come in the last few minutes, and I welcome your comments. One is several people have asked, where may they get a copy of the practice guide that you referred to?
The practice guide published at the time, I think the date is in mid-August. I can't recall exactly, but it's published in the Federal Register. If you Google it, I assure you, you will find it. Oh, and it's also on the website. Thank you. Yes. So if you just go to our website, and I think it says AI Resources, I think that's what you click, and it would be there. Sure.
Another question that came in was, could you say something about why backup counsel is required and what effect this would have on somebody who's a sole practitioner who would like to represent a client in one of these proceedings?
Backup counsel is required because we need someone to converse with when we can't find lead counsel, mainly, and that happens not infrequently. There are times when there is a pressing issue and one side desperately needs a conference call, and we can't have a conference call with just one party. It's an inter-parties proceeding, so we need to have both of you on the phone when we speak. If we can't find lead counsel, we need to find backup counsel.
So every party taking part in one of these proceedings, whether they're initiating or essentially responding to it, on either side they have to have backup counsel.
That's correct.
Okay, thank you. Another question that came in approximately 40 times is, can we download these slides? And the answer is yes. Everybody who registered will have received 3 emails, one approximately 13 hours ago, one 6 hours ago, 7 hours ago now, and the other one 2 hours ago, an email, the subject line of which started with the word reminder, and within that email is a place where there's a link that would let you download and print out these slides. So the slides are available to you. It is our intention, we are recording this program, and I will later confer with people at the Patent Office to see if the Patent Office is comfortable letting the recording be published, and if the answer is yes, I'll make sure to put something in our newsletter about it, but there's a chance that a recording might be available. Let me turn to a couple of other questions that came in. Will the discovery in these proceedings before the board, will the discovery be controlled by the federal rules of civil procedure that relate to discovery, interrogatories, depositions, all that sort of thing?
Generally, if you look in our practice guide, we do refer to some of those rules for certain aspects. I don't think it's a total adoption of those rules. I just wanted to go back to that question about the counsel, because that sounded like kind of a harsh response I gave. And I just wanted to say that if you have a particular situation where it's a real hardship to obtain both lead and backup counsel, that's the kind of thing you could call and discuss with the judge. Generally, yes, you do need both. I can say that there would never be a situation where we would not make an exception.
Thank you, Judge Lane. One of the questions that just came in is if somebody does a pre-issuance submission, do they have to reveal who their real party in interest is, or can that be done, if you will, as a sort of an anonymous submission?
Real party in interest can be anonymous in here. However, the submission itself has to be signed, because if you recall, there are certain statements that have to be made in that submission, such as it's not, the real party in interest is not a 56C party, and that there is compliance with the regulations. So the submitter has to be identified. The third party, to remain anonymous, will have to get someone not associated with the third party to be the submitter. And in that case, you can keep the third party to be anonymous.
Judge Lane, a question came in. What's going to happen to somebody who exceeds their page limits? You're free to give a humorous answer or a real answer.
Well, I will say that if you want to exceed your page limit in your petition, there's a mechanism for doing that, and it's set out in the practice guide. And essentially, you're going to have to file the petition within the page limit, and then you'd have to file the petition that you would ask us, the one that exceeds the page limit, and file that with a motion to accept, and the longer one. So essentially, you're filing a motion for a page limit extension. The reason we do that with the petition is because that's the only time you don't have a judge assigned to your case, so you don't have someone to call up and say, hey, can I file an extra 20 pages? Thereafter, if you want to file extra pages, you're going to have to consult with one of the judges and get an order allowing you to do that. Now, if you actually file it when you shouldn't have because you didn't have authorization, then we will just expunge it from the record. And that could be a problem if that's going to cause you to miss a filing date. So I would not recommend that course of action.
Another question that came in, and my best guess is that it's probably too early to even comment on this, and you may not want to comment anyway, but somebody has asked, what, if anything, can you say about how work is allocated within the three-judge panel or how the panels get appointed?
Well, again, as you say, that would be kind of hard for me to say at this point because we haven't done any of these new proceedings. I mean, generally at the board, there's a number one judge assigned who is mainly responsible for the case, and then the other panel members are there with an equal and as important vote, though.
Thank you. I'd like to talk just a little bit more about timing of how one knows whether to use an old language declaration or a new language declaration, and this is directed to Hiram. One of the questions that came in is, suppose an application was filed before September 16th, 2012 without a declaration, and suppose the USPTO later mails out notice of missing parts or whatever, some document that tells them they have to hand in the oath or declaration, and the handing in would be after September 16th, 2012. Is it going to be an old language declaration to satisfy that requirement or a new language declaration?
Yeah, old language declaration, because the filing date of the application is prior to September 16th.
Okay, so to rephrase that, so the filing date of the application is what's going to determine the choice of language, not the timing of a notice of missing parts or the timing of the submission. Right. And as a sort of related question, just for emphasis on this now, PCT application filed before September 16th, national phase entered after, would it be the old language or the new language that would apply?
And First of all, the manual MPP 1890 something or other section, there's a whole paragraph that talks about 371 national stage applications, that they are not a new application, they are just the international application entering the national stage. So the filing date on that is not when they enter the national stage, the filing date is of the international application. So if you have an international application that is filed before September 16th, that is old language declaration. Even though the national stage is entered after September 16th, it is still an application filed before September 16th.
Thank you. I'm just going to take a look here, pick out one or two more of the questions here. We have actually a group of about 3 questions here from 3 different people that are somewhat tied together, and this is directed to Judge Lane, and I will guess that it's probably too soon to answer any of these because probably some law will have to be developed, but are you able to say anything about the definition of data processing or other operations for financial product or service? And it will not surprise you, the next person wanted to know, how do we know what is a technological invention? With the sort of warning that it's probably too soon to answer any of these, I guess I would invite any comment you might have.
Well, I agree. I think that we've provided a definition for technological invention based on what guidance we received from Congress. I think that the definition does provide a fair amount of guidance, but we are hopeful that in the very near future, as soon as these things start coming in and going out, we will have some case law guidance for you all.
Another question for Judge Lane. Do claim charts count as a portion of the page limit?
They do. They will. If you choose to include a claim chart, they will count. That's why we changed it to single spacing so that that could help you out. Someone had asked a question the other day, if a claim chart is within an expert witness's declaration, does that count? And the answer is no. So
I think
not to give any secret weapons to anyone, but since the question came out and they got the answer, I'll give it to you guys as well.
Opening big enough to drive a truck through.
I may regret that.
We have something for Hiram.
Right. I just don't want the door to be opened in supplementals and third-party submissions, for example. There may be some thought, well, I can throw in some items of information in the request itself. I urge you to go back to how we count things again. We pull those items out. For example, if you're just talking about enablement and there's no document and it's just involved in the discussion, that will count as an item.
Another question that came in, this may have been prompted by my using the acronym SNQ. Can we explain what an SNQ is? And of course, it stands for Substantial New Question. And I wonder if either of you would like to say another sentence or two about substantial new question.
I believe that we have a definition for SNQ in the manual, 2242, and I'll read you the definition that we have. Where there is a substantial likelihood that a reasonable examiner would consider the item of information important in determining patentability. Sounds like the old 56 standard, but that's what we're using for SNQ.
Thank you. Another question that came in, will a patent that has been subject to one of these proceedings, IPR, PGR, CBM, when the proceeding is over, will there be something like a reexamination certificate showing up in the patent itself, or do people learn what happened only by reviewing some sort of database at the PTAB?
I suspect it will be something like we do with interferences now, which we put a copy of the judgment and the administrative record of both. In the case of interferences, the patent and the application, but in this case, a copy of the judgment would go into the patent file.
Another question that comes in, actually it's come in about 4 times. I'll try to sort of combine them all into a single question. Judge Lane, can you say anything about the staffing of the board and extent to which the board has been increased in size to accommodate the different kinds of proceedings that we heard about today?
Yes, we have been gearing up for these new proceedings for some time. We have, I'm sure a lot of you are aware, we've hired a large number of new judges, more than in the entire time since I've been in the board at one time. That has required us to do a lot of training, but we think we've done a pretty good job with that. A lot of the more experienced judges have stepped up and helped with that, so I think we're going to be prepared.
Thank you, Judge Lane. Another question that came in, this is for Hiram. Suppose we have a newly filed patent application after September 16th, 2012, an application whose effective filing date under Section 120 is prior to September 16th. Parent case is prior to September 16th, and what is being filed now is after September 16th, continuation or divisional. Should I be using a new language declaration or an old language declaration?
Okay. Sometimes these questions are so general that we miss some wrinkles in here, but let me give you the general answer. It goes by filing date of an application. So if you're telling me you filed a 120 application, that is a new application. The filing date of that application would govern. So if a continuation or a CIP is filed after September 16th, the only declaration that you can get into that would be a declaration that is compliant with the AIA requirements.
Yep. I think that's the answer I would have given too, but I love hearing it straight from Hiram. Okay. Will there be a fee for filing a declaration after filing the application, but before a notice of allowability is issued? Yeah, the regular $130 fee that we all know and love, and that is reduced to $65 if you're a small entity.
But there is no surcharge for coming in with an application data sheet after the application is filed. The only surcharge you'd be paying is for the declaration coming in late. There's not a dual surcharge there.
But the filer that is dragging their feet and only hands in the ADS until later is delaying the eventual release of the application to the examining court.
You're absolutely correct.
Okay.
Could be a strategy.
As a sort of a best practices point, if someone is a foot dragger and holds off handing in their inventor's declarations until long after filing, and in the particular case where the application we're talking about is a national phase from a PCT, there is going to be a loss of patent term adjustment. And this isn't the fault of how the rules are written or anything else. It's just that the rules make very clear that that the date by which one completes a number of national phase entry requirements is the date that starts one of the time periods running for PTA. So if you wanted to make a list of all the reasons why it's good not to drag your feet on the oath or declaration of inventors, patent term adjustment is one of those points.
I want to get back to the application data sheet submission for a moment. While the office doesn't want me to harp on this, the requirement for an application data sheet, if you're not coming in with the deck or you're delaying the deck, is not a filing date requirement. So you're not going to lose a filing date for it coming in. However, the longer you delay in coming in with the application data sheet, the office may become of the opinion that the applicants are the inventors rather than an assignee or something that would be set forth in the application data sheet. And to change that type of presumption that we would have, you would have to go via Part 3 as opposed to just directly naming yourself as an assignee in the application data sheet.
Thank you. I'm just taking a look through, trying to pick out one or two more questions from our okay, question. Can a party that has been sued for infringement and that has counterclaimed for invalidity in the same action file an inter-parties review?
Sorry, I'm going to have to ask you to repeat that.
Yeah, and I'm going to have to repeat it myself. Can a party that has been sued for infringement, an accused infringer, I assume we mean in a federal district court action, and who has counterclaimed for invalidity in the same action, again in the district court, can they then file an inter-parties review?
they have to file within 1 year of the time they're sued for infringement.
Thank you. All right. So we are almost we're almost out of time here. We have 30 seconds left. What I'm going to do at this point is thank Judge Lane and thank Hiram Bernstein for giving their valuable time for the last 2 hours. I'd also like to thank our audience, which has given us many, many good questions. I apologize that time has not permitted us to cover all of them. I'd like to thank the Patent Office for providing all the resources that made this possible. As I say, if circumstances permit, we may be able to post a recording of the webinar, and if we do, I'll be sure to announce it. And I will definitely find a way to post the slides. Well, the slides have already been posted, but I'll find a way to give that link to people who did not already have that link. With that, I will say thank you very much, everyone, and I'll wish everyone a good day. Thank you.